quite surreal waiting, isn't it, like this?
I know. Will Joe let us know when we have enough people?
Yeah, it looks like we've got 30 at the moment. Hello, everyone.
Goodness. Hello.
We're just going to wait a few more minutes for everyone to join before we start. If you've just joined us, we're just waiting a few more minutes so that we've got our participants all here. Jay, how are we doing for participants? Okay, Mark, I think we can start.
Excellent. Well, good afternoon, everybody. I'm Mark Goldshire, barrister at Falcon Chambers, and I'm delighted to be here as a guest of Five Stone Buildings to talk to Eliza Eagling about the Human Rights Act and its application to property and trust cases. We're going to talk mostly to Eliza about her recent case of Reed-Druce, but we're going to start off by doing a brief recap of the Human Rights Act. It's an area that comes up from time to time in chancery work, and it's very interesting when it does. But Eliza, I've not done a Human Rights Act case for a little while, so could you just remind me of exactly how the Human Rights Act works and the Section 3 and Section 4 provisions?
Absolutely, but before I head in, I'll just do a very quick few housekeeping points, just to remind everybody that this is being recorded. You can ask questions. There's a Q&A box at the bottom of your screen. If you want to be anonymous, you can tick a box to say that, and we'll try and deal with questions at the end. But if we don't have time, then we can send out email answers if appropriate. So I think that, Mark, were there any other housekeeping issues that I've forgotten there?
No, you've remembered everything, I think. So yes, we can get into the meat of it.
And we're not going to have slides during this talk. So Joe, you can go to normal screen now, but we will send out, thank you very much. We will send out a sheet at the end with the cases that we've referred to. So, Human Rights Act, just a reminder of how it works. So, until from the 1960s onwards, what British citizens could do if they had a breach of their rights under the European Convention on Human Rights, which I refer to as the Convention, is they'd have to go to Strasbourg, which is a bit of a faff. So, the idea of the Human Rights Act is to bring the rights home, to incorporate, at least to some extent, the rights directly into UK domestic legislation. And in order for there to be a breach, the act needs to have been done, or the omission, by a public authority. And that is made clear by Section 6 of the Human Rights Act. That provides that it is unlawful for a public authority to act in a way which is incompatible with a convention right. And that's something worth remembering. I don't know what you think, Mark, but I like the idea of there being vertical rights, because there has to be something as between an individual and the state, not horizontal, which would be between individuals and individuals. And we'll come back to that, because we'll have to understand why the human rights therefore affects wills and trusts. But anyway, so there we have it, public authority. And I think the key provisions are sections 3 and 4 of the Act, and that provides a judge with a choice. If there has been a breach of a convention right by a public authority, then the court can either read down the offending legislation under section 3, or if it feels that's not possible, and Mark is about to tell us why it might not be possible, then it can do a declaration of incompatibility under section 4. So Mark, I think your chambers was involved in one of the leading cases on reading down, and when that is possible under section 3. So can you briefly tell us all a bit about that?
Thanks, Eliza. Yes, so Jonathan Small from my chambers took to the House of Lords the case of Guyden and Godin Mendoza. It's probably quite familiar in its outcome, but the facts are quite interesting. It was a case under the Rent Act about who would succeed to a statutory protected tenancy. These are very valuable tenancies. And the question is, when the original tenant dies, who gets to take over the tenancy? Now, you go all the way back in the history of the Rent Act. Rather shockingly, the original version said it was just the widow. And that went to the Court of Appeal, and they said, yes, widow means widow, woman only. Parliament thought that was probably a bit outdated and amended the legislation. So it said, okay, now it can be spouse. If you're a surviving spouse, then you get to inherit. Time moved on. In 1988, Parliament amended it again, and they said, if you are living with the original tenant as his or her wife or husband, then you can succeed. Yeah.
Would that basically be cohabitants?
Exactly, yes. So it's a cohabitant of a sufficient length and duration and permanency. So there's a lot of references to it not including lovers. It has to be something more permanent than that. But that's exactly right. The question that came up in this case was, well, what about same-sex couples? Because you've got that gendered language in there, his or her, wife or husband. Can it apply to a same-sex couple? Mr. Godin Mendoza was in that situation. He was a tenant. He'd been living with a same-sex partner for a long time, and he wanted to succeed. So that's the facts. It had to go all the way to the House of Lords, because in 1999, and this, of course, is after the Human Rights Act was enacted, but before it came into force, in Fitzpatrick and Sterling Housing Association, this exact question had come up to the House of Lords, and the House of Lords has said, no, it doesn't include same-sex couples. You're part of their family, but you're not in this wife or husband category. So the question is, what difference did the Human Rights Act change? And as Eliza said, the court first had to say, well, has there been legislation which infringes convention rights? And the answer, I think, unsurprisingly, is yes. Article 14 about discrimination on the basis of sexuality, taken together with Article 8, right to family life. This legislation clearly infringes those rights. And the court then had this choice. Do they do something under Section 3 to fix the legislation, or do they give a declaration of incompatibility under Section 4? Now, it's a split decision, and the dissent is actually quite compelling. So this is what Lord Millett said. He said, imagine you have an act that says that it applies to red, green, and blue. can you say by section 3 it also applies to yellow? He says no, it says red, green and blue, and that's what it means. You can't add in a new colour. The majority said just because it is inconsistent with the wording of the legislation, that doesn't mean it's impossible to fix it. You can read in this case, words that say living with them as if they were his or her wife or husband, and therefore same sex is included. So that, I think, is an illustration of just how dramatic the effect is. You can simply just add in words that extend the protection of an act to people who were clearly not envisaged by Parliament. So that's the sort of basis of this. But Eliza, what does that say? Yeah.
I was just going to say that I'm just thinking about reading down. I mean, reading down is a bit euphemistic then, really, as a phrase, isn't it? If by reading down, you really mean kind of reading up or reading wider, I don't know. But
absolutely, and it's particularly striking because while they were deciding Guided Mendoza, the Civil Partnerships Bill was going through Parliament, and what that was going to do was actually to add in different words that just said or civil partner. And as you say, Eliza, that wouldn't cover every cohabitant. It would only cover those that entered into a civil partnership. So it's saying Parliament got it wrong before. Parliament is going to get it wrong when it fixes it in a minute. So we're going to rewrite the legislation with new words that do what we think the convention would require. So it is quite interventionist. Yeah. And so, as you said, Eliza, one would think this has got absolutely nothing to do with wills and trusts because that's people's private lives and they can do whatever they want. But I gather that's not the case.
Not quite the case, no. There have actually been 3, I would say, main cases in the area of Human Rights Act coming up into contact with wills and trusts. And those are Erskine, which was decided in 2012, Hand and George, which was decided in 2017, and the recent case of Redress that I was involved with Henry Legg QC, and that was the end of December last year. By the way, I can see a few people have joined us. We are recording this, so if you've missed the start of this, don't worry, you can always catch up with the beginning online later on. And in terms of those 3 cases, Mrs. Justice Rose in Hand and George said that she had reached the provisional view that she wasn't going to, that she disagreed with some aspects of Erskine, and that she thought that it was inconsistent with some House of Lords decision. So she didn't follow Erskine, and she came up with her own structure, and that was a structure that we applied in Juice. So given this is a 30-minute talk, I'm not going to go into Erskine, but it is worth remembering that none of these decisions have gone above the High Court judge level, and so you know, it's all up for grabs, and it may be worth reading that decision in your own time.
Thanks, Liza. So it sounds like we should start with Hand and George in that case. And the question that's still in my mind is, well, okay, in Guidon we had the rent tax, and that was a discriminatory piece of legislation. But what could possibly be affecting this in a trust situation?
Well, that's a good point, because it's worth remembering, although I would say if my mother is listening to this talk, if you can do that, but everyone else should listen, is of course well-known testamentary freedom in this country. You can be as discriminatory as you like as a private individual. The issue was, in this case, is there was what was seen to be discriminatory legislation. And the discriminatory legislation was the Adoption Act 1976. And I'll just set out a few of the facts so you can understand why the Adoption Act was relevant. Mr. Henry Hand, he died in 1947. And I think if you take away one thing from this talk, it is that dates are really, really very important. So he died in 1947. He left a will dated 1946, well before the Human Rights Act came into force. And by his will, he left the residue of his estate to his 3 children in equal shares for life. And then on the death of each respective life tenant, their share was to go to their child or children, if more than one in equal shares, absolutely. And the 2 previous, there were 3 children, as I said, and 2 of them had died long ago. And the last child, Kenneth, he died in 2008. And the issue for the court was that he didn't have any biological children, he only had 2 adopted children. And it is clear under common law that the word child or children, same thing for issue and descendants, means biological children only. So that didn't help the two adopted children of Kenneth. And then, as I said, the way we get the Human Rights Act in is because there was an Adoption Act, the Adoption Act 1976, and it provides that adopted children are to be treated as the child of their adopter, including for succession. But there are transitional provisions, which mean that those provisions that affect property rights only apply for instruments that post-date the coming into force of the Act, which was 1976, and this was a 1946 will. So because of the transitional provisions of the Adoption Act, the children didn't inherit. So they were coming before Mrs. Justice Rose to say, please apply Human Rights Act, please save us on that front.
So that sounds really interesting, because you say dates really matter. If his will had been made in, say, 1986, they would have been absolutely fine.
Yeah.
And it sounds like the intention of the Human Rights Act, of the Adoption Act, was to basically have this line, say, if you've made a discriminatory will before this act, fine, but now you're all on notice. If you want to exclude adopted children, you're going to have to say so in terms.
Of course, and I think, Mark, it's interesting because, of course, you say it's a discriminatory will, but, you know, one of the themes I think that comes up from this talk in the Human Rights Act is the change in social values. I mean, just look at your case, Guyden. I mean, presumably, I mean, Mr. Han may well have been aware at the time in 1946 that child didn't include adopted children. He could have, of course, put that in, but he didn't. But that may well be, he probably didn't consider that to be discriminatory, taking into account the social values at that time. So, I mean, obviously now it looks to us discriminatory.
No, absolutely. So that, I think, probably takes us on to the first bit of Mrs. Justice Rose's test, because I think she had a sort of helpful structure, and starting with this question of, you know, is it okay or is it discriminatory? So how did she actually approach it?
Yeah, well, she had a very, very clear sort of structure, in my view. She went through 4 different questions and she answered them, taking into account the answer, then she'd move on to the next one. And that is how, in the end, answering yes to all 4 questions, she found that it would be appropriate to read down the legislation. But I'll go through the 4 questions. The first is, are rights under the European Convention engaged? And that's essential because, as I said at the beginning of this talk, what the Human Rights Act does is bring the Convention rights home. And the rights in question here are Article 8, which is the right to family life, and Article 14, which is the discrimination provision. And there have been a number of Strasbourg decisions which make absolutely clear that treating adopted and natural children, or illegitimate and natural children, differently, including in the inheritance sphere, is a breach of their right to family life, in conjunction with the anti-discrimination provision. And interestingly, Mark, I think it was exactly those articles of the convention that were engaged in Guyden. It was Article 8 and Article 14. Yes,
that's right. And certainly, as far as I'm aware, most of the cases go down that route and protect those rights. Whether they would extend it to other rights is unclear. We'll watch this space. If anybody knows of any cases, do give us a shout.
Yes. So first question, are there convention rights engaged? Because that's sort of threshold. Tick. Yes. Move on to the next one. Are the transitional provisions of the legislation in breach of the those convention rights? And the question about that is, just because you've got rights that are breached doesn't necessarily mean that it's the legislation that is at fault. Because, as we said, I mean, in theory, you know, if a mother or father discriminated in their private will against adopted children, then that might be, in theory, a breach of their rights, but not ones that can actually be used to bring in or engage the Human Rights Act, because there wouldn't be necessarily a act of the public authority. But here there is an act of the public authority, that being Parliament with the Adoption Act 1976, because the transitional provisions meant that the Act did not apply to Kenneth's children, because, just to remind you, it only applies post 1976, and we've got a 1946 will. So, tick, we have a public authority in breach. Third question, and this brings us back to, Mark, what you were talking about. can the transitional provisions be read down under section 3? And Mrs. Justice Rose says yes. And the language from Guyden is, does the reading down go against the grain of the Act, or alternatively, does the reading down, is it consistent with the thrust of the Act? And Mrs. Justice Rose said this, I mean, I'm summarising, but she said that the whole purpose of the Adoption Act is to expand and improve the rights for adopted children, and that they be treated the same as natural children. That's the sort of purpose of it. And so if we read down the transitional provisions, so it doesn't affect these children from under a 1946 will, then that is going with the grain of the legislation. So she said, yes, that's fine. And the last point was, is the application of the Human Rights Act inappropriately retrospective? And what does that mean? Well, in the leading case of Wilson and others, a House of Lords decision from 2004, the House of Lords said that the Human Rights Act shouldn't be applied retrospectively. Makes sense. And the sort of language they used was, is there a pre-act event or is there a post-act event? And you might think, well, hang on a minute, look at these facts. We've got a will from 1946, a testator from 1947, legislation from 1976. How on earth can this not be retrospective? But Mrs. Justice Rose found our post-act event, and the post-act event is the death of the last life tenant, because it was his children that were adopted. He dies in 2008. And so she says the question arose then in 2008. So that's not retrospective, because we're looking at the Human Rights Act and the Strasbourg Court as at, well now, and there's no retrospectivity. So, so that's how she got to her decision.
That's fascinating, Liza. I mean, it's interesting. I think on the retrospectivity, I'm sort of okay with that, because the same kind of situation happened in Guyden. The tenancy was made back in the 1980s. There's no real decision to make about who inherits until you have the death of the tenant, which in that case was 2001. So the question doesn't come up until the death of the relevant person, and then the question is who inherits. But the reading down is quite striking. I mean, you know, sticking with our colour idea, it's as if the Act says red and green, but not scarlet. And the reading down says, oh, don't worry about the not scarlet. The general thrust is to include red. So just delete the scarlet provision. And that's really, really quite striking. And I don't know whether you, I mean, I know you went on to build on this very successfully, but it does seem, you know, stretching to the limits what is possible under Section 3.
Possibly. I mean, I can come on to talk about that actually in relation to Druce, because in Druce, you know, again, this was, well, it was in the area of trusts and estates, but in some ways quite different from Hand, because this was an inter vivos settlement created by John Druce in 1959. He didn't have any children. So he did what all good uncles do. I hope my uncle's listening to this. What he did was leave the trust fund on discretionary trust for the descendants, the male descendants of his siblings. And there were 4 siblings. And the issue was that the word descendants, like issue and children, at common law means biological or natural children only. And we had some great sort of family trees. They were all color-coded and spreadsheets. And we had 30 natural male beneficiaries that we called beneficiaries capital B. And then we had 4 illegitimates. We had one where there was an adoption issue. We had one who was legitimated who was illegitimate when born, but legitimated as a matter of New Zealand law, which raised some conflict of law issues, but not relevant to the Human Rights Act. And we also had one on ventre sa mère, who was going to be born after the vesting day. Again, really interesting. Do read the judgment, but not relevant for human rights. So what are the differences between that and Hand and George? Well, we've got adopted and illegitimate. So it's the first case that I'm aware of that deals with illegitimates. And also, in terms of retrospectivity, we don't just have the death of a life tenant, we have ongoing trust powers that sort of span the coming into force of the Human Rights Act.
And that I think is really interesting, Eliza, because I think this is where I have a few more questions about the retrospectivity, because it's not just a one-off moment when, you know, the question gets asked, who inherits, who doesn't. This is a question the trustees have had to ask every year or every period since the settlement, and you know, you're now changing the exercise of their discretion, but it does seem very interesting. You mentioned about illegitimate. I mean, I imagine there's a lot of practical difficulties in tracking down all these people literally to the ends of the earth if they're in New Zealand.
Yes, well, so I discovered. I mean, there's lots and lots to be said on the kind of practicalities to consider, and perhaps that's a talk for another day. But one thing I discovered was that whilst genealogical research is pretty good at turning up adopted children, for example, it's very difficult to track down illegitimate unless you have both parents, but you might not necessarily be, you know, you might not know that you're to look for an illegitimate child, and even if you do know that, you might not have both parents. So as the only female member of our all-male team, I was tasked with trying to write a delicate letter to every single woman on our tree, which sort of went along the lines of, you know, lovely weather, isn't it, you know, wonderful, just, you know, dropping in touch to see if you've had any illegitimate children, and oh yes, and we're only interested in the males. And whilst I tried to be delicate about this, it turns out it's very difficult to ask these questions in a delicate way. And we did get some quite horrified letters back saying, you know, why are you asking these questions? Why does it matter in this day and age? And why not women? And of course, the answer to the why not women is because, as we try to explain, you know, the issue was not the discriminatory provisions per se of the settlement. The issue was the legislation, which was the Adoption Act 1976 and the Family Law Act, Family Law Reform Act 1987, which the transitional provisions of which discriminated against adopted and illegitimate. But I'm not sure that satisfied them, but, you know, we did our best.
No, that is fascinating. The female natural descendants, no recourse under the Human Rights Act at all. Seems nonetheless, despite this uphill struggle, you managed to persuade the court in the face of stiff opposition.
Well, Mark, I would love to say it was a fought battle, but actually, remarkably, we did this under Section 48 of the Administration of Justice Act, which is where if there's no dispute, then a court can proceed on the basis of counsel's opinion. It's got to be counsel of 10 years call, so that was my leader, Mr. Legg, QC, who wrote the opinion. And actually, we sent the opinions. There were actually 3 because of all the different issues that arose. And also we kept having more pop up. As I said, illegitimates pretty difficult to track down, and then we'd find another one. We sent them out to all adult male beneficiaries, i.e. the ones who would stand to benefit without question, and they actually all agreed, which we were really shocked by. So you know, we went to court, but we had all the written consents. No, we didn't actually have any defendants. And actually, I was very, when I went to court to just to make sure we could issue without the defendants, the master sort of peered over me and said, "Miss Eagling, you've ticked the Human Rights Act box. I've never seen this. What are you doing?" That was a great moment. Anyway, so yes, no defendants. That's the summary.
Well, that's good. I mean, I think when we've talked about this, there are sort of areas you could really get at. And this reading down point is really interesting. And while we were preparing this, the Court of Appeal handed down its judgment in the McConnell case. So it was quite well publicised. This is a transgender man who gave birth to a child after gender transition and after gender recognition under the Gender Recognition Act. And what he wanted was to be recorded not as mother on the birth certificate, but as father or as parent. And it really struck me reading that the Court of Appeal took a very different approach to sort of exception provisions in the Gender Recognition Act. And I don't know if you had thoughts about that.
Well, generally, I mean, going back to Druce, I mean, what is surprising is that that Mrs. Justice, well, perhaps surprising, is that Mrs. Justice Rose did take the decision that the transitional provisions can be read down so that effectively they don't take effect. Because actually, as you're saying, Mark, exceptions can be all important. I mean, this is a bit of a facetious point, but if we just look at the coronavirus regulations, and I should say I'm not giving advice and I'm not a criminal lawyer, but I mean, if you look at that, you can say, well, the grain of the legislation is to have us all at home, and you know, exceptions are neither here nor there. So, I mean, if you just look at the coronavirus regulations, exceptions can be all important. And it seems to me that what the transitional provisions are doing in the Adoption Act, in the Family Law Reform Act, and they also exist in the Gender Recognition Act, in all of these provisions, legislation, the point of the transitional provisions, I think, is to balance, you know, testators' intentions or settlers' intentions with the kind of change in social values. Because the point is that before the relevant act came into force, the testator or settler will understand what, say, child means, and if they want to include child before 1976, if they want to include an adopted child, they know they need to put the adopted reference to an adopted child in, whereas after 1976 they need to exclude reference to the adopted child. And I think the problem with reading down the transitional provisions is that you're sort of taking away the testator or settler's choice before the act came into force. So I think the acts are maybe a very delicate balancing balancing act, which is being affected by this reading down. I mean, the question is it appropriate, I suppose?
No, exactly. And I think that's the other thing I think is very interesting in the McConnell judgment. What they say there is, given this choice between Section 3 and Section 4, you should be very careful, because they say, look, they knew Mr. McConnell wouldn't want to be recorded as mother, but they said they didn't know what other trans men might want in that situation. And also, as they say, you know, Parliament has been very specific, and there may be reasons underlying that. So I think, and that, you know, in my mind, goes all the way back to Guyton. You know, as say, the Civil Partnerships Bill was going through, and the court still stepped in to fill the gap. It's obviously still a very hot topic and fascinating area. I mean, I gather there's still quite a lot of things in the pipeline in other areas on this.
Yeah, I mean, Sharia law is really interesting. There's some great Strasbourg Sharia law cases. I'm very much hoping that there's going to be some Sharia law cases here, and there's questions about whether you approach this from, you know, the gender discrimination perspective or from a religious perspective, and obviously it's a bit of a hot potato. There's a case going through Strasbourg at the moment where the firstborn women would like to inherit House of Lords seats, and whether that's possible or not, although there's a bit of a backlog in Strasbourg, so we're waiting there. There's obviously the Gender Recognition Act, that's currently being, I think there may be a new Gender Recognition Act, but it'll be interesting to see if they still have the transitional provisions. So it's a real sort of expanding area, and I think that kind of takes us to the end. But if you do have any questions, do feel free to email us. I mean, it's such a rich area, there's so much to look into. Mark, I don't know if you had any other final comments.
No, just I found it absolutely fascinating reading into this, and it is all back to social values against individual rights. It's been a fascinating area, and I hope it's been informative and entertaining for those watching at home.
Brilliant. Well, thank you very much, everyone.
Thanks.